Hello friends and welcome to the lecture. So students, as we know that we are covering the Panchayati Raj, okay? And basically these are the topics we have scheduled for the discussion under this particular series, okay? Like the introduction part, thereafter the evolution of Panchayati Raj, thereafter the 73rd Amendment Act of 1992, thereafter the compulsory and the voluntary provisions, thereafter the PASA Act of 1996, also known as Extension Act, thereafter the Finances of Panchayati Raj, thereafter the reasons for the ineffective performance. So these are the topics basically we have scheduled for the discussion. Out of this, we have done with the introduction part, evolution of Panchayati Raj, 73rd Amendment Act of 1992, compulsory and the voluntary provisions. Thereafter the PASA Act of 1996, Extension Act. And the topics we are completely left with is the finances of the Panchayati Raj and the reasons for ineffective performance. So that's the picture we have created all together. So basically we will start from where we had left in the previous lecture. Like we had done with the objectives and we were to cover the features of the act. But before starting today's session, let us revise some previous facts and figures which we had discussed. Okay. So we know that the first district which adopted the Panchayati Raj is the Nagaur. The first district, the first state which adopted the Panchayati Raj was the, you can say, the Rajasthan. But I'm going to ask you a different question. Like we know that the Balwant Rai Mehta Committee, okay, it is the committee which purpose the three-tier government or the three-tier panchayat. Okay, that is what we know. And what is the name of these three tiers? Gram Sabha, Panchayat Samiti, and Jila Parishad. Okay, now I'm going to ask you a different question, like which was the first committee to propose the two-tier panchayat system? Three-tier we had discussed, but the question is which was the first committee to propose the two-tier panchayat system? 30 seconds you have to think an answer, then I will give you the answer. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. So time's up. The correct answer is Ashok Mehta Committee. So the Ashok Mehta Committee was the first committee to propose the two-tier panchayat system. Next question is also related with the same, like which were the tiers of panchayat proposed by the Ashok Mehta Committee. Like we know that Ashok Mehta Committee proposed two tiers, but what was the name of those two tiers? Okay, or what was the label, you can say. So you have again 20 seconds to think and answer, then I will give you the answer. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20. The time's up. The correct answer is Block Panchayat and Jila Parishad. Okay. So instead of the Gram Sabha, the Block Panchayat and the Jila Parishad, the Ashok Mehta committee simply said that we should only propose two, like the Block Panchayat and the Jila Parishad. Now, the third question I'm going to ask you is that which states having exemption from the Panchayat system? Which states having acceptance from the Panchayat system? 30 seconds you have to think and answer. Let me give you the hint that the 73rd Amendment Act is not applicable in these states directly. Okay, so your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So those states are states of Nagaland, Meghalaya, and Mizoram. Nagaland, Meghalaya, and Mizoram. So these are the states in which the 73rd Amendment Act does not applicable directly. Okay. The next question I'm going to ask you is very latest. Like, what is the full form of PAISA Act? What is the full form of PAISA Act? Again, you have 30 seconds to think and answer, then I will give you the answer. So, your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So basically, the correct answer for this question is Provisions of Panchayat extension to Schedule Areas Act. Okay, so that's the full form. The Provisions of Panchayat extension to Schedule Areas Act. Now, let me ask you very simple and the quick question, like what is the year of the PAISA Act? Okay, for this again 20 seconds you have, then I will give you the answer and your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20. The times up. The year was 1996. In the year of 1996, the PASA Act was passed. Okay, so that is just a quick revision of the things which we had discussed so far. After this, now we are going to talk about the features of the Act, of the PASA Act, which stands for the Provisions of Panchayat Extension to Scheduled Areas Act. So the features of the provisions of the PASA Act are as follows. The first, the state legislation on the panchayats in the scheduled areas shall be in consonance with the customary law, social and the religious practices, and traditional management practices of the community resources. Okay, so basically it is mean that whenever the state legislation will try to formulate any rules regarding the panchayat in the matters of the scheduled areas, so those rules are not on the discretionary on the state legislation like in the normal areas, but they must be in consent with the customary law of the communities, social and the religious practices of the communities, traditional management practices of the community resources. Okay, on the basis of this only they could formulate the rules. Thereafter, a village shall ordinarily consist of a habitation or a group of habitations or a hamlet or a group of hamlets comprising a community and managing its affairs in accordance with the traditions in customs. Okay, like under PESA, if they are declaring anything as a village, so that must be a habitation or a group of habitations. It means the group of villages, or a hamlet or a group of hamlets. It means a small, you can say the huts and all. And this must be a community which is managing its affairs accordance with the tradition and custom. It means there must be uniqueness in their rules and regulations. Then only the extra protection could be granted. Every village shall have a Gram Sabha consisting of persons whose names are included in the electoral rolls for the panchayat at the village level. It means that when we talk about the Gram Sabha, okay, so basically Gram Sabha consisting the persons whose names are included in the electoral rolls for the panchayat at village level. For example, suppose if there are total 10,000 teenagers living in a village right now, but out of this only the 9,000 teenagers having their names in the electoral rolls. Okay, so only the 9,000s will be the members of Gram Sabha. The rest 1,000 will only the tenants living there. All right. Thereafter, every Gram Sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, community resources, and the customary mode of dispute resolution. It means that whatsoever the Gram Sabha will be formed, that must be competent, or you can say must be capable enough to safeguard and preserve the traditions and the customs of the people, their cultural identity, their community resources, and their customary mode of dispute resolution. Okay, which means custom rules and regulations. Thereafter, fifth point is every Gram Sabha shall first approve of the plans, programs and projects for the social economic development before they are taken up implementation by the panchayat at the village level. Okay, it means that if we talk about the village panchayat, so whatever the implementation regarding the plans, programs and the projects for the socio-economic development the panchayat is going to do, that must be approved by the Gram Sabha. Until or unless the Gram Sabha does not approve, or you can say until or unless Gram Sabha approves the plan, programs and the projects, the panchayat would not be able to implement them. Thereafter, be responsible for the identification of beneficiaries under the poverty alleviation and other programs. Okay. So what does it mean? It means that there will be a community approval for the identification instead of discretionary approval of the panchayat. Okay. Thereafter, every panchayat at the village level shall be required to obtain from the Gram Sabha a certification of utilization of funds for the above plans, programs and the projects. Okay. It means that until or unless the Gram Sabha provides a certification of utilization funds for the plans, programs and projects the panchayat is planning, okay, the fund will not be issued to them. Okay. Thereafter, the reservation of seats in the scheduled areas in every panchayat shall be in proportion to the population of the communities for whom reservation is sought to be given under part 9th of the constitution. Okay, it means that the population portion, or you can say proportion, will be under consideration while providing the reservation as per the provisions of part 9th of the constitution. However, the reservation for the scheduled tribe shall not be less than one half of the total seats or the total number of seats. Okay, it means that for the scheduled caste, for the scheduled caste, the reservation portion will be depend upon the you can say population proportion in the entire population. But when it's come to the scheduled tribes, then doesn't matter what is the population of them, but the reservation must be one half of the total number of seats, could not below it. Further, all assets or you can say all seats of chairpersons of panchayat at all levels shall be reserved for the scheduled tribes. Okay, when it's come to the Paisa Act, not in the ordinary situations. Thereafter, the state government may nominate such scheduled tribes with no representations in the panchayat at the intermediate level or panchayat at the district levels. But such nomination shall not exceed 1/10 of the total members to be elected in that panchayat. It means that suppose if the scheduled tribes not getting representation at panchayat, okay, or you can say having inadequate representations. So it is on the state government that they could nominate the such scheduled tribes, okay, at the intermediate level, the block samiti, or at the district level, the Jila Parishad. But there is a condition or there is a rule. Such nomination shall not exceed the 1/10 of the total members to be elected in that panchayat. Okay, it means that there will be a balanced approach between nominated and elected. The Gram Sabha or the Panchayats at the appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development programs, projects, and before resettling or rehabilitating persons affected by such projects in the scheduled areas. Okay, like the government, or you can say the any authority of the government, could not directly replace dwellings of the people who are living in the scheduled areas. Okay, they are required to consult it with the Gram Sabha or the Panchayat at appropriate level. Then only the things could be done. However, the actual planning and the implementation of the projects in the scheduled area shall be coordinated at the state level. Okay, because it is on the state property. Thereafter, the planning and management of minor water bodies in the scheduled area shall be entrusted to the Panchayat at the appropriate level. Okay, or you can say minor water bodies is also the local or regional water bodies. Okay, thereafter the recommendations of the Gram Sabha or the Panchayats at the appropriate level shall be mandatory for grant of prospecting license or mining license for minor minerals in the scheduled areas. Okay, it means that if the mining site is for the minor minerals, it means that they are not so important for the state economy. Then basically in the scheduled areas, the recommendations of the Gram Sabha or the Panchayats at appropriate level is necessary, or you can say the mandatory. But when it's on the state level, and you can say when the major minerals are there, which could bring the better opportunities for the state and the nations as well. So basically the role is granted to the state government. Okay. Thereafter, the prior recommendations of the Gram Sabha or the Panchayats at the appropriate level shall be mandatory for grant of concession for the exploitation of minor minerals by auction. Okay. Thereafter, 13 Act is that while endowing panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of the self-government. Our state legislature shall ensure that the panchayats at the appropriate level and the Gram Sabha are endowed specifically with the following powers. The power to enforce the prohibition or to regulate or restrict the consumption of the intoxicant. The first thing. Thereafter, the ownership of minor forest produce. Remember, minor forest produce, not the state forest or major forest produce. Why? Because they comes under the state government. The power to prevent alienation of sand in the scheduled areas and to take appropriate action to restore any unlawfully aliena land of scheduled tribes. Okay. Thereafter, the power to manage the village markets. Also, you can call it as a local markets. All right. Thereafter, the power to exercise control over money lending to the scheduled tribes, the power to exercise control over institutions and functionary all social sectors, the power to control local plans and resources for such including tribal subplans. All right, these are the things. 14th point is that the state legislations shall contain safeguards to ensure that panchayats at higher level do not assume the powers and authority of any panchayat at the lower level or at the Gram Sabha. That is also we had discussed in the previous lecture. The state legislature shall endeavor to follow the pattern of the sixth schedule to the constitution while designing the administrative arrangements in the panchayat at district levels in the scheduled areas. Okay. Point 16 is any provision of any law which is relating to the panchayats in the scheduled areas which is inconsistent with the provisions of this act shall cease to be enforced at the expiry of 1 year from the date on which this act received the assents of the president. Okay. However, all the panchayat existing immediately before such date shall continue till the expiry of their term unless dissolved by the state legislature sooner. That is also we had discussed. Okay. So students, basically in this lecture we have finished the PASA Act of 1996. In the next lecture we will start with the finances of the Panchayati Raj. Till then, just revise the facts and figures we have discussed in this lecture and be ready for the another lecture. With this note, we are going to end this lecture and thank you.